Welcome to our continuing 2018 educational webinar series. I am Catherine Short, Partnership Marketing Specialist for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliant management solution tailored to your business. A hospital, hospital network, healthcare practice of any size, billing company, or skilled nursing facility. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. We are so pleased to have Sean McKenna of Greenberg Traurig and Mike McCarthy of Cooper Health System presenting Trendspotting, False Claims Act Enforcement in Healthcare. Sean McKenna focuses his practice on healthcare enforcement and regulatory issues representing individuals and providers under civil or administrative investigation by the Department of Justice, Offices of Inspector General, and Attorneys General Medicaid Fraud Control Units, as well as in criminal investigations and matters involving the United States and state attorneys general. Sean's areas of concentration include False Claims Act quitam, defense of government investigations including criminal and white-collar matters, healthcare litigation, and regulatory issues. As former 10-year Assistant United States Attorney General, Associate Counsel to the Inspector General, and General Counsel to the United States Department of Health and Human Services, Sean focuses his practice on matters involving the healthcare industry and regularly represents clients before Medicare, Medicaid, and commercial contractors. Sean's work includes assisting clients with internal investigations and compliance reviews, as well as advising on compliance with state and federal fraud and abuse rules. He is a frequently invited speaker at national, regional, and local conferences. Michael J. McCarthy is an Associate General Counsel for the Cooper Health System in Camden, New Jersey. Mr. McCarthy primarily advises Cooper on compliance issues, privacy, business transactions, and the 340B drug discount program. Cooper University Healthcare is the leading provider of comprehensive health services, medical education, and clinical research in southern New Jersey. Before joining Cooper, Mr. McCarthy was an assistant United States attorney in the Northern District of Texas, where he was a member of the Dallas Medicare Strike Force. A copy of the slide deck is available for download on the control panel. Feel free to submit questions in the question box of your control panel during the presentation. We will address questions at the conclusion of the presentation. Your Paycom CEU certificate will be emailed to you from Paycom following the broadcast. There is no need to request it. Additional CEU opportunities will be available to BC Advantage members following the live broadcast. See their website for details. Michael, Sean, go ahead.
Well, thank you very much, Catherine, and welcome everybody, and appreciate you listening to this presentation. Mike and I have known each other for many years, worked together as federal prosecutors, and we're going to give you an overview of kind of healthcare fraud enforcement activity recently and in 2018. And as we go to the overview, we're going to talk about some of the government agencies and procedures and responding and conducting internal investigations and responding to inquiries from law enforcement. And then we'll have time for a few questions at the end. So let's talk about the enforcement agenda and then go to the next slide. Right now, the current administration has, up until recently, been relatively silent in the area of healthcare fraud, except for the fact that they express interest in continuing to bring individuals and corporate executives accused of fraud in civil and criminal administrative cases. But, Mike, as we'll talk about in the next few slides, that has somewhat changed in the last few days when there's been some groundbreaking memorandums released by the U.S. Department of Justice involving kind of new, I guess, procedures or at least philosophies involving the prosecution of healthcare cases.
Yeah, that's right, Sean. I think that, if you were to ask the government, they would say, well, nothing's changed. But as you'll see when we discuss these memoranda, that's potentially not true. There's reason to believe that in 2018 we will see a departure from what the previous enforcement scheme has looked like.
Right. In fact, several months ago, the Deputy Attorney General spoke to a industry group and talked about how they would be reevaluating some of the procedures and tightening them. And so rather than bring informal guidance, they want to go bring back to the statutory and the regulatory law, which has the force and effect of law. That's referenced in the Granton and Brand memos, as we'll discuss. So let's talk about the enforcement outlook in 2018. Still problematic in the sense that there's budgetary shortfalls, which means an increased focus on trying to prevent fraud, waste, and abuse. The perception, at least from the public or the media, is that fraud is rampant. And every time there's a large case brought by either a civil or criminal restitution or a civil key tam case, whistleblower case, and then that kind of reinforces that perception. The kind of trend I've noticed, Mike, and maybe you've seen this as well, is that the commercial payers are becoming extremely aggressive in attempting to collect and ensure medical necessity and that there's no physician inducement in the referrals. And I've seen that in my practice. And I guess from a hospital perspective, have you seen a tightening up on that side as well?
Yeah. So laboratories, I think it's maybe laboratory testing is one good sort of area there where you've seen a lot of action by private payers. It's for labs, it's tough because of capitation. And there are some bad actors out there. There were some bad actors out there. And there have been some pretty big decisions and lawsuits that were not initiated by the government. They were initiated by the payers.
Yeah, absolutely. We've seen some of the largest commercial payers as they continue to consolidate and become essentially providers themselves, which presents some awkwardness as well on both sides of the house. But they have increasingly gone after medical necessity, both the federal and these commercial payers. But also, they've been using very aggressive tactics, and we'll talk a little bit about that as we get to the agencies as well. I think also some of the trends that we're seeing is the increased and continued use of data analytics to kind of find and identify those outliers, especially as you pointed out in certain ancillary spaces, as well as any hospital systems utilizing those outside resources. And there's still the continued focus on individual actors, but we'll talk about that, how it might be changed here in a little bit. And then let's go to the next slide, Mike. The enforcement outlook continued. The OIG work plan that was recently issued for kind of the next fiscal year, I guess 2018, talks about, the standard issues, the E&M and upcoding and everything that has been going on for probably the last 20, 25 years since the inception of these plans. But we're also talking about there's increased focus on telehealth services, and I think the opioid issue, Mike, and you've been seeing it probably in essentially a public nonprofit hospital setting in New Jersey. That's become a huge issue, especially for physicians and pharmacies.
Yeah, absolutely. Well, let's start off with the fact that it puts a huge strain on hospital resources. Dealing with opioid overdoses, and Narcan has saved a lot of lives, but a lot of these people are administered Narcan and they just end up, right back in your emergency department. So that's going to be something that's so high visible as opioid abuse is going to be part of the OIG's work plan, which is updated frequently, but you're going to see that throughout the whole year. And to advance to the next slide.
Right. Yeah. Mike, talk to us about kind of what President Trump has announced, kind of your understanding of what that means.
Well, opioid crisis, I think, is something that everyone would agree is going on. But when the president does it, it means that you're going to see a lot of resources devoted to opioid treatment, cracking down on opioids at a street level. Here in New Jersey, what that has meant is so it's something that was actually presaged by Governor Christie, focusing on this at the tail end of his administration. And there's not a ton of increased enforcement, except to say that it's even more visible than ever and they have more money to enforce it. there's a lot of focus on treatment facilities, and especially the fraud that has gone on with treatment facilities that were nothing but sham facilities. Right. And I think you've seen some of those lawsuits in Florida and some prosecutions for that. But that is really just the tip of the iceberg when you talk about patients who are literally being moved all around the country and just shipped from fraudulent facility to fraudulent facility. So I think in 2018, you're going to see those prosecutions sort of bear fruit and become real cases. And I think they're going to be a new feature to the enforcement landscape in 2018.
Right, Mike. I mean, I know in Texas and South Florida, the so-called sober treatment facilities have been under scrutiny especially because they utilize, the urine toxicology testing and some other pharmacological studies and issues. But there's also the allegations of collecting or monetization of patients almost and using gift cards to attract those types of individuals. So you're right. I do see those and those are mostly criminal cases because I think a lot of the commercial payers have caught on and not necessarily Medicare or Medicaid. But let's go to the next slide, talk about recent DOJ activity. And then, right now, you were part of the Medicare strike force back almost in its inception in Dallas back in 2008, 10 years ago now. And it's continued to be a huge initiative for the Department of Justice. We've seen it spread across the country in the so-called high fraud areas and an increased
That's right. There's, I think wherever you see a strike force, wherever there's been a strike force city, there is going to be a lot of enforcement activity. South Florida is an example, Brooklyn. Wherever there is a strike force, there will be an increase in indictments and increase in enforcement actions. I want to highlight the last bullet point here, the number of qui tam lawsuits. It goes up and up, basically, starting from 2015. And there's some consequences for that, as we're going to see in the next slide, or the slide after this next one. And the problem is, as these qui tam lawsuits have increased in number, the Justice Department has not increased the amount of resources available to deal with them. But before we go into the implications of that, let's talk about the Yates Memorandum. It was issued September 9th, 2015, and officially titled Individual Accountability for Corporate Wrongdoing. And like probably the next two memorandums that we're going to take a look at, the official Washington, if you will, stance on this is, listen, this has always been here. We're just sort of bringing it front and center for you. Really, that hasn't quite been the case, because ever since the Yates Memorandum, individual accountability has been a feature of negotiations, and you have just seen pure numbers. From a pure numbers perspective, the amount of individuals being a part of False Claims Act actions increase. It just wasn't all that common that you would see hospital executives, for example, be part of a False Claims Act settlement, or executives or members of a practice group instead of the practice group itself. But that's something that's becoming more and more common.
Got it. Go ahead.
Go ahead.
No, I was just going to say that obviously DOJ has continued to recover billions of dollars, and the slide, I think, speaks for itself. But one thing, Mike, as you know, that most of these cases and the recoveries, the big ones anyhow, arise from so-called whistleblower suits under the False Claims Act, qui tam suits. And so we're not really going to address the statutes or talk about those types of cases, but just know that they are prevalent and they do drive both the criminal and then also administratively, because let's not forget about the administrative agencies and their administrative remedies, exclusion, et cetera. All right?
Right. So Sean, in talking about the Yates Memorandum, when we're entering into settlement negotiations with the government, is it common that the government will leverage sort of individual accountability in order to they offer cooperation to large providers and try and sort of extract information about individuals?
I think that's a fair statement. I mean, I'm sure DOJ would not use the term leverage, Mike, but I do believe that essentially that's what it is. They're focused on the corporate entity. And years ago, when I handled these cases, and I was, did these for 10 years, civil and criminal cases, but normally you would have the company would pay a fine, and that was the perception. And I think the Yates Memorandum is exactly kind of a reaction from the prior administration to the financial crisis where no one was criminally held accountable. So, okay, let's focus on those individuals. So now the Yates Memorandum essentially says that for a company to not be charged or get cooperation credit, whatever that means, then they have to essentially provide information regarding the individuals, because the individuals essentially bind the company, and they're the ones who are, quote, the wrongful actors. And the perception has been that these individual executives have not been held accountable. So we have a shift in 2015 to focus not only on the corporate entities for paying a fine, et cetera, but also focusing on criminal or administrative or even civil recoveries against executives, which presents a very awkward ethical issue for defense counsel, because your longtime client can be a CEO of a hospital system like you, Mike, or deputy general counsel or whoever, and then all of a sudden you've got to say, well, I have a conflict now because I represent the company and I have to get you spin-off counsel. And I really think this has slowed down the resolution of some of these cases from DOJ as they sit and linger or refer administratively individuals out. Mike, why don't you talk to us about the Granton Memo that came out recently?
Yeah, this is the next memorandum that we're going to discuss. This is, I guess, leaked, but the memo itself was dated January 10th, 2018, and was written by Michael Granton, who's the director of the DOJ Commercial Litigation Branch. And this memorandum was addressed to all AUSAs handling False Claims Act cases at all the U.S. attorneys' offices in the country. And it addressed dismissal of QTAM lawsuits under Section 3730 C2A, which is not new. It's not like this was added. It was more a exhortation, I guess, to these AUSAs to be more aggressive about using 3730 C2A to dismiss certain QTAMs. And I think a lot of this turns out to be common sense once you look at the effect of the increase of QTAMs filed on the Department of Justice, as I alluded to earlier. Because you got to realize, if DOJ sort of determines that a QTAM is frivolous, or they want to decline to intervene for some other reason, they still potentially bear some burden in terms of resources. They also will, DOJ runs the risk of an adverse decision in a case that they didn't participate in. So it's there's a risk there as well. And in the memorandum, Mr. Granton identified 7 factors, the Granton factors, and they kind of allude to what I was just talking about. Curbing meritless QTAMs. Just in general, the government should be serving as a gatekeeper for these, because after all, they're brought on behalf of the government, standing in the shoes of the government. So the Department of Justice really should bear some responsibility for getting rid of meritless QTAMs.
Right.
Go ahead.
Mike, what I was going to say is that you're absolutely right. I handled a bunch of cases that maybe not frivolous, but just couldn't be proved, or just wasn't there. And so rather than simply declining it, or because the court had cut the time period for the government to investigate off at some period of time, the government increasingly has been following these not intervening at these times, which are essentially treated as a declination. And the courts are frowning on that. So I think this memorandum is a response to that, not only the lack of resources in monitoring these declined or not intervened cases, which potentially creates bad law that does bind DOJ, which that's why they file statements of interest, amicus briefs, etc. But ultimately trying to resolve and get rid of those cases, because it's fundamentally unfair. If the government thinks there's no case here, then the relator, shouldn't have to go forward. Now, that's frankly, from contrary position, is statutorily contraindicated, because the FCA expressly allows relators to go forward. And Senator Grassley, who still sits on the Judiciary Committee, has been a champion of the False Claims Act amendments and whistleblowers in general. So this is a marked departure. And I was at the conference when Granton made these alleged remarks, which then were retracted by the Department of Justice and now issued in a leaked memorandum, which I think everybody has a copy of at this point. All you have to do is go online and search for it. But I do think, this is a market trend and gives DOJ some leverage, because there have been these increased litigations, or if the government continues to investigate but hasn't intervened, then you have to force actual litigation. So it presents a tremendous financial and resource intensive burden on providers and defendants in these cases.
Right, and from the perspective of a provider, it's a relief, just the discovery process alone, even for a meritless claim that will likely, be dismissed. It still costs a lot of money. And
the e-discovery alone to produce search terms, even for emails, or an active litigation is, hundreds of thousands of dollars potentially, depending on the size of the provider. So I do think that's a fair point. But Mike, why don't we move on to the brand memo? And why don't you tell us a little bit about this? This just came out, I believe, the last several weeks, and is getting a lot of press as of late.
Exactly. January 25th, 2018. And to quote from the memo, I think one of the most important pieces is the department may not use its enforcement authority to convert agency guidance documents into binding rules. And I think where everybody went first was reasonable and necessary. And the fact that that was being defined by the government in using sub-regulatory documentation.
It's interesting, Mike, because on this memorandum came out, I think it's a direct response, and there's been a leak of private emails between DOJ and a prominent defense attorney, and actually discussing kind of the use of what we call sub-regulatory guidance, which does not have the force and effect of law. For instance, it's either a statute or a regulation, and that is a law, but then the guidance issued by the agency, either through state operations manual or some other Medicare benefit policy or some, NDA or coverage determination, or even something from a contractor, is often used to bootstrap as evidence of falsity in these FCA cases. I think it's still relevant, Mike, to consider that it could be used as potent knowledge of what at least the government's position is, but I don't think you can use it to prove falsity. And the big issue is that in the advisory opinion process, those are binding on the requesters only, but everybody else in the industry, when you're structuring transactions for fraud and abuse concerns for the anti-kickback statute or Stark law or state law, looks to those as interpretive and kind of binding guidance. And now, rather than the FCA in these investigations, whether whistleblowers or the Department of Justice bringing these cases, or even the states, I think is really going to be hamstrung and relying on advisory opinions as kind of the quote, the law, so to speak. And it has historically, especially in these kickback and Stark cases.
Right. So in cases where, you have a defendant who's provided care that's so substandard, the government says, and such a departure from the industry standard, wouldn't like in this case cited here, Polikoff, the government would call an expert who would cite to the American Heart Association or to illustrate the standard of care. but it's
right.
different when you're giving it basically the force of law, and that's the distinguishing thing here.
Absolutely, because there's an increase, as we pointed out on one of the original slides in this presentation. Department of Justice no longer shies away from medical necessity cases and is increasingly bringing them, whether it's kind of home health, DME, whether the medical necessity becomes an issue, especially under the False Claims Act. And I do think that you're absolutely correct. I mean, this use of sub-regulatory guidance or instructions is something that this administration seems to be shying away from, and that's what was signaled, I believe, back in the fall, and now we're seeing the fruits of that in the memorandum. So, but Mike, why don't we talk a little bit about just briefly resources, information, and I can, go from there.
Right. So actually, you could also title this slide "Sub-Regulatory Regulation."
That's true.
Because but at the same time, while the government isn't going to use some of the sub-regulatory guidance in the way they have in the past, these are all very useful, to help your compliance program. And advisory opinions are great; they're very specific. But there's a ton of sub-regulatory guides that you can find in these resources that is very helpful for preempting any government intervention. In other words, when you want to conduct internal audits or boost your compliance program.
Absolutely, Mike. I think, the problem is this. I mean, these are very useful guidance to avoid getting yourself in a situation where you actually have to use the brand guidance in the Granton Memorandum to defend yourself in a False Claims Act. You'd rather avoid that altogether. So this is the barometer of it. And, the prime example, I think, was several years ago when one of the Medicare contractors issued a guidance of their interpretation of what is homebound for home health services, which was vigorously fought by the industry. And because they amalgamated certain things in the particular industry guidance issued out there, the Medicare benefit policy. And that was a huge issue and continues to be an issue today. But you're right. These are just examples, again, press releases especially as well. Why don't we talk about government agencies? And obviously, Mike, I don't think we can just go through this quickly, that Department of Justice essentially has civil and criminal branches. Consumer Protection Branch addresses food, drug, cosmetic cases exclusively. Those can be handled in the regions. And I know, Mike, you handled a few when you were an AUSA, but you really got dedicated prosecutors, both civil and criminal, to handle healthcare cases, and now in some districts, opioid cases as well. But the FBI is really, and the DEA have really become kind of preeminent in these types of cases, given what the trends we're seeing. But the last point is the public-private. Now, special investigative units often are staffed with former law enforcement officials, especially FBI, and the FBI has exclusive jurisdiction to address insurance fraud and various commercial payers. And so the payers have been presenting cases to the Department of Justice to bring. And I think a lot of people believe that only federally funded cases can be brought in civil and criminal cases by the Department of Justice. But that's true for the False Claims Act, but in criminal settings, they can bring purely commercial cases. And in fact, there's a host of cases around the country now where they're using state commercial bribery cases and federal criminal cases. Let's go to the other enforcement players, Mike, if we could.
Yep.
And again, we mentioned the special investigative units, but this just is a laundry list of everyone who really has a role to play in assisting the Department of Justice in these False Claims Act and these criminal cases. I think obviously the last point to me is the most important, because whistleblowers generate most of the cases under the False Claims Act, and it has only increased over time. You're seeing about an average of 700 per year, and the recoveries obviously can be tens of millions of dollars to them or hundreds of millions of dollars to them, but also billions of dollars back to the federal funds and the programs.
Right. We had mentioned in an earlier slide the increased use of analytics by the government to detect fraud. Do you feel like the analytics are used predominantly in the criminal setting?
I do believe that, especially in the strike force, Mike. I think data analytics has become so sophisticated. When I started as an AUSA and handling FCA cases back in 2003, there was just certain types of cases, especially hospice or home health, that had a benefit period rather than a distinct supplier or a Part B claim. Hit for $1,500. They were very difficult to bring and calculate supposed damages. And now the government relies on contractors and the analytics to really extract that data, and they have access to it almost immediately. So it has really revolutionized the ability of DOJ to bring more sophisticated cases, which is why I think they're touching into the medical necessity.
Right. And, with analytics, at least from the strike force perspective, it was, it's been in front of you the whole time, but analytics will help you find these low-hanging fruit with, for example, an ophthalmologist who's the #1 prescriber of OxyContin in the state. These sort of glaring problems, and that you would never know until you put all this data together and analyzed it. And the strike force was meant to bring these cases quickly.
Right, and I also think that those cases have bleed over because they often are focused on practitioners or clinical personnel who have relationships with other entities, and so I think there is that bleed over effect where scrutiny happens. So a lot of people say, well, we don't do that. We're not criminals. We don't do that. But some of the vendors or some of the people you may do business may have problems that you're unaware of. That's why I think it's important from a compliance perspective and trying to rebut allegations that you failed to knowingly monitor staff or marketing people to get as much attestations and much due diligence on the front end to be able to point to that when law enforcement knocks and say, hey, we did everything we possibly could to rebut the presumption that under the False Claims Act, you knew or should have known, which is defined as deliberate ignorance or reckless disregard, which is a very watered down standard. So, Mike, why don't we talk? Tell us a little. Go ahead.
Yeah, let's continue on to sources of investigative cases. Is something we've sort of already touched on.
Right.
We just discussed data mining. So let's look at the common risk areas. So I think one thing I want to talk to you about is retention of overpayments, because I know that's something that when you talk about compliance, it can't just be handled by the General Counsel and Chief Compliance Officers. That sort of relationship can be good to detect, but you have to do the work of figuring out, well, how much is the overpayment? And you have to involve a team of people at your organization. So I think that's just a practical challenge of retention of overpayments.
Well, it's true. I mean, another thing under the False Claims Act, Mike, under the recent, not so recent legislation, but under the Affordable Care Act and the FARA statute from, I guess, 2008, now a knowing retention of an overpayment is actual violation of the False Claims Act. So whereas before it was questionable whether that could trigger civil or criminal liability, now it's expressly stated that failure to make a repayment as far as a timely manner within 60 days, at least for Medicare and Medicaid claims, is a violation of the False Claims Act. And there's nothing easier for the DOJ or whistleblower to prove than you knew there's a problem, you failed to make the repayment. So that internal analysis, whether through counsel or not, is so critical now and so important. So one of the things we tell clients and providers is that if you think there's an issue, you need to reach up and lift it up to your compliance officers and advise them, and just don't sit on it and let the time go by, because it's a very strict standard and the time clock goes quickly.
Right, and I think that you don't want to worry about being off by a little bit. In other words, you have 60 days to return the overpayment. And if you're coming up on the 60 days and there may be a little bit here or there that is in question, you need to make that overpayment and not have to try and make the case that, well, or the delay was reasonable, or
right.
at least payback ones you know for sure fall under this standard.
And one of the things I've done, it may be impossible in 60 days, we may have blown the 60 days, But, even sending some correspondence to the contractor saying we've identified a problem, we're in the process of quantifying it, I think that goes a long way. So you can try and avoid the idea that, sure, you may have an overpayment, but it doesn't necessarily rise to a criminal or civil violation. And I've seen other people and clients who have been sued under the False Claims Act, for that reason. Well, you knew there was a problem. You failed to do it in a timely manner, and then a whistleblower filed a suit in the interim. And then instead of just simply making a check or repayment, then they're under the multiplier of the False Claims Act and the potential penalties.
Exactly. If you for sure identified an amount that needs to be repaid, and you're bumping up against 60 days, pay that amount at least. And then you're right, correspond with whomever you're making the repayment to. Right.
And Mike, I think the risk area is continued. I think this is very straightforward, and I think the audience can read this, but I do believe that, any physician-owned entities present a risk to an organization, just because there seems to be the perception that if I don't take federal funds, I'm okay. But we're seeing that's not the case, because federal criminal law is now being applied to federalized state commercial bribery statutes so it's not in any kickback statute or Stark issue per se, but it's still kind of in a financial, bribery or conflict issue. But the rest of them, I think, are relatively straightforward. But we continue to see, and I've been doing this for 20 years, Mike, medical directorships, kind of practice acquisitions. Fair market value is critical when evaluating and structuring these transactions.
Exactly. And especially practice acquisition. People are fighting for the last scraps of independent practice groups these days. And medical directorships for sure. A lot of times a medical director can have the keys to hold the key to referrals, and that's an area where you need to be very careful.
Right, especially with increased competition among the providers, like a state like Texas, which is not a certificate of need state, for instance.
Right.
There are hospitals and clinics on every corner, and there's fierce competition for those referrals. And then you start to see, hey, practice, and then, factoring as fair market value goodwill, which the jury seems to be out on. But it's a very, kind of tough dynamic, which is, I think, getting an independent evaluator to provide, kind of a blanket against the allegations of illegal inducements, et cetera. But Mike, going to government investigations, I mean, in your experience, obviously these are all different types of things, but we talked about key TANs, but I really think the bread and butter is the subpoenas, and what type of subpoena you get dictates what type of investigation you're under, potentially. Is that right?
That's true. With getting a grand jury subpoena, I think being has the potential for the worst case scenario. It doesn't necessarily mean that's going to be the case, but you're thinking criminal. But getting a subpoena doesn't necessarily mean that you're the focus of an investigation.
Right. I mean, I think that's incumbent on, if you are a recipient of a subpoena, increasingly under the False Claims Act, we're seeing the use of CIDs recently, not recently now, but the legislation allowed the delegation for the local U.S. attorneys to actually handle CIDs. And I think that's now the preferred, which can compel testimony under oath, interrogatories, and also production of documents. And I'm seeing in my practice, that's almost become, you never see an Inspector General or an AID subpoena as much anymore. You only see CIDs, especially in the False Claims Act world.
So you sort of touched on it, but could you explain just a little bit more specifically what CIDs are?
Yeah, absolutely. So I'm using the nomenclature all in healthcare here. So it's a civil investigative demand, and specifically under the False Claims Act statute, it authorizes the Attorney General essentially to issue a civil subpoena compelling testimony or documents or compelling answers under oath. And so while the grand jury can compel testimony that's purely in a criminal case, now specifically under the False Claims Act, whether they're accused of a violation or you're simply a witness, they can get that testimony under oath. Becomes very powerful. In a lot of ways, I think it's streamlined the way these cases are brought, because the knock historically has been, for the most time, that these cases go under seal for years and years and years and years. And it's essentially tantamount to a violation of due process. So the courts are really ratcheting down on how long the Department of Justice has to investigate these cases under seal. So they'll issue these CIDs right away and ask for documents within 30 days, which is a very short time frame, but it really kind of gets the case moving and up and running. So from a defense perspective, it's a kind of a scrambling to get to know a new client or an existing client, and from an IT and the preservation of issues, et cetera.
Let's look at the next level, which is what the government's going to do with that information. We'll go through this very quickly. I think really the second to last bullet point, knowledge and intent evidence is what can make or break a case. I think you probably agree with that, Sean.
Absolutely. I mean, it all comes down to, you're going to have a claim, you're going to have a contract of some sort, you're going to have payments, and I think, whether they're overtly or, indirectly false or fraudulent becomes more material now under Escobar, which is a Supreme Court decision now being interpreted by the courts, whether it's the decision, to make payment or the alleged fraud was a material falsity in the determination to make, payment. It used to be that the government could just say, had I known it was procured by X, I would not have paid that. And then that kind of got you over the hurdle. Now the courts are really stressing, okay, is this alleged deficiency fraudulent, or is it really material to the decision to make payment? And I think there's sweeping cases and there's circuit opinions all over the place. And it's really kind of, we'll see this issue, I think, before the Supreme Court, especially in the next probably 2 or 3 years again, as, discrepancies among the circuits continue. But you're right. I mean, the one thing, too, also is that we haven't touched on it really because it's a little beyond this presentation, but the civil, criminal, administrative, and then even the state potential or licensure. I mean, the government has so many different ways to proceed. They can do it at the same time or sequentially, et cetera. And so when you're representing an individual in an FCA case, I just don't think you can assume, right, Mike, that it's just a civil case, but there's potential other liabilities out there, let alone even potentially private litigation, which could commence immediately and then be used as a conduit to provide information to the government.
Right, exactly. You touched on a good one, which is licensure. We may avoid some of the other enforcement apparatuses that we talked about, but if your license is in jeopardy, you might as well have paid back money, or I think you would rather you pay back money. So there are a lot of when you would know this, when you have a client who is facing these subpoenas, and that the government is gathering all this information sort of behind the scenes, they have to be protected on multiple fronts.
Yeah, absolutely. And again, that results in a lot of potential ethical issues from the individuals, going back to the Yates Memorandum. But also, I think clients just have to understand that when you're being kind of confronted on all ends, what's the focus of the defense? I think you have to be clear when counseling clients, Mike, and from your perspective too, what is the end game here? Obviously, I think most people say they don't want to go to jail. Okay, we understand that, but that has potential implications on the civil side or the licensure side. And then again, private liability, especially if it has to do with medical necessities, is becoming a huge issue. When I was a prosecutor, I had people in civil discovery, publicly available documents. If there was litigation involved, I would just drop a subpoena on the law firm and get a copy of the documents, because there's no way that they, even though it's confidential or it's under a confidentiality agreement, government can ask for it. So I think that presented a lot of challenge for defendants. But kind of going to the next one, Mike, on Internal Investigations 101, and this is essentially what you would do when faced with a FCA inquiry or subpoena, identify what the issues are, et cetera, but you would go through an internal investigation. But the key component is the last point, the remedial measures. Maybe you get wind of an issue and you conduct an internal investigation, Mike. I know you do that all the time with your facility, but you may not have an FCA case, but one may crop up, a year or two later. And I think from your perspective, the remedial measures you put in, repayment, disclosure, whatever it is, are critical to rebutting the allegations of knowledge under the False Claims Act.
Yes, and also, so if retooling your compliance program, for example, can help you even if you're going to get in trouble. If your response is, consistent with a legitimate concern about compliance, then that's going to help you in negotiations with the government. So you want to be the person who says, this is just, the one time the puck got through the goalie, but we have a goalie, and we have a system that is set up to detect fraud, to basically a robust compliance program. And if that turns out not to be the case, still, you should be taking those measures immediately so that you can at least say to the government, okay, we didn't have an effective compliance program, but now we do.
And I think that's
only going to help
critical component. Yeah, I mean, from either a criminal perspective or civil, having an effective and demonstratively effective compliance program by catching these problems really can go, and it's directly in DOJ guidance and the United States Attorney's Manual, which is binding on DOJ into their own internal policies, but they're supposed to take that into account when assessing potential liability from enforcement actions. But Mike, talk to us a little bit about some of these common triggers. I mean, these are all relatively straightforward, but anything that kind of from your experience stands out as one of the most common issues that kind of to pay attention to?
I don't know if it's common personally to me, but I think the departing employees issue is interesting, because I know that there are people who will try and, or there have been cases where providers have made disgruntled employees sign confidentiality agreements, for example, that would purport to prevent them from revealing any information about they learned while they were in the employment of a fraudster. That's not going to work. But one thing you can do is do a real exit interview, and and encourage honesty, and have a way of moving information from the interviewer to compliance, similar, to a hotline call,
right?
Where you can, someone tells you something, and maybe they're a potential relator, but best case scenario, it's a way for you to make your organization better and more compliant.
Yeah, and I think just from a tactical perspective, I agree with that, Mike. It's just you lock in that person, because you may know they may want to file something, whether it's employment related or under the False Claims Act, but you lock them in, you give them an opportunity to talk to anybody else. Did you say anything else? What'd you do? Okay, great. And then you take action on it. And if for some reason they say later on, I told them about the following, and you can just produce that. No, you didn't, because we conducted an exit interview and they never mentioned that. So we were never put on notice of that. Otherwise, clearly we would have fixed that issue. But also, I think that departing employees, when they start to be contacted by law enforcement, or you start to hear rumors circulating in the industry among competitors or former employees, or whoever, it's a good indication something might be up, and you may want to kind of hone in on that from a compliance perspective. Mike, let's talk a little bit about the next slide. I know we're kind of winding down on our time here, but any points that you have on preliminary assessment?
You got to get together the relevant individuals. It's better to, that's the first step, right? You want to assess, what do we have here? And kind of to your point of what to do with information, how to act upon information given to you by a departing employee, go out there and speak to people, and have discussions with people, and you got to get there as quickly as possible, but be as broad as possible to make sure you don't miss anything. Absolutely.
And I'd also echo that, this is a very fluid type of situation, responding to an investigation. Things change, but in my experience, you talk to 3 or 4 people, you kind of get the gist of what needs to be done, and you can identify those individuals. I think clearly when you get notice of an issue, you've got to preserve the evidence. We talk about that and how you go about doing that, litigation hold, et cetera. But I think that's critical, especially if you get a subpoena. But then we're talking about the investigative plan here, Mike. I think that's relatively straightforward. We talk about the document preservation and collection, because nothing screams, fraud to the government as if you can't keep the information that they think you should have. And I know it's frustrating because not every organization is huge or a national company. It may not have a document retention plan or something to that effect. It may not have access of employees, personal identifiers. But I think increasingly the DOJ is now talking about our subpoenas and our CIDs cover personal devices of your employees. And so you're really going to have to go out there potentially and get that information, because a lot of the physicians, a lot of employees, marketing reps, et cetera, communicate by text. But trying to handle and get a marshal on information is extremely difficult, because most of the time it's not around by the time the subpoena comes 2 years later.
Right. That's also in the malpractice world. So you're right. With bring your own devices. The challenge for collecting this evidence is huge. And we talked earlier about cost. The cost is also huge.
Right. Just hiring a forensic person to go out there and image a bunch of phones. That's why I think it's critical to have a rapport with the regulator in question, whoever it is, to try and narrow that scope and just say, this is ridiculous. The sheer amount of information and cost. One of my last cases I handled when I was at AUSA was against a large national device manufacturer, and I asked for electronic information. And I think the response was, that literally will cost us $4 million based on what you're asking. And so my natural response, of course, Michael, is, well, you can just pay us the $4 million instead. We'll call it a day. But
we'll go away. We'll go away.
Yeah, exactly. But let's talk briefly, because I know we are winding down, about interviews. And Mike, when you're conducting these internally, are you present, in-house lawyer present? Who do you like to have in the room, especially if it's an important witness?
It depends. But a lot of times, no. It's just outside counsel. But it depends on what the subject of the investigation.
Yeah, I think you'd agree, though. You probably don't want any management personnel attending, correct? Maybe just simply an introduction, because I think that has a chilling effect. And then, the upjohn warning, which essentially is telling employees, when you're conducting an internal investigation, hey, because everyone thinks you're their lawyer, right, Mike, especially internally. So You've got to be clear and tell them that I'm not your lawyer, I represent the company. If you need your own lawyer, that's fine. But this is a confidential, privileged discussion, and even if you talk to anybody else, it doesn't waive it, and that's a standard upjohn warning. And I think it's important for individuals to get that. And I also think my personal practice is that if you know that person is suspect or has done something improper when you're doing just an internal investigation, I don't like to interview them knowing that. I frankly think it's from more of an ethics thing, just to say, I think you got trouble. I think you got to have your own lawyer, because I don't want to be accused of duping or providing, kind of misrepresenting why I'm there, and then having some judge frown upon it later when I try and introduce it as evidence. I don't know, Mike, what are your thoughts?
I think that's a good practice, because the power relationship is going to be so unbalanced, potentially. Certainly that's how it's going to be painted by that person's lawyer later down the road, without a doubt. That no amount of admonishments or any admonishments you give will be called legalese by someone later down the road. It's probably best to make it much cleaner.
Right, and especially if the issues are that raises some potential Fourth Amendment issues. Are you acting as an agent for the government and collecting this, especially if you are turning some of this information over? I think it's just best practice to make sure that you don't have that kind of that specter over your internal investigation. But moving on to one of the last slides, implementing corrective action. Mike, when you're handling this and there has an issue, it has to be resolved. Who's the messenger you send, either to the government or internally or both?
So implementing corrective action internally is you got to identify I hate to use corporate speak, but the sort of change agent who's going to be able to not just implement but monitor, because I think that's key. When you're talking about corrective action, you can have the greatest plan in the world that the best lawyers, the best compliance officers have concocted. But if the people who are actually dealing with relationships and patients and all this other stuff every day, if they're not aware of the why, or if they're not being monitored throughout, past the implementation stage, then you might as well not have done it.
That's a great point, because one of the things I've seen, you communicate the corrective action, especially in light of an FCA case, for instance, and a resolution. Okay, and going forward, we're going to do the following, whether you have a corporate integrity agreement attached to it or not, and then failing to follow up and making sure that operations or even compliance is doing what they need to do, because that's just a hallmark of someone, to the government anyhow, that just doesn't get it and is a recidivist or doesn't care, which I think is devastating to try and determine, especially if there's a subsequent investigation or some spinoff or litigation, et cetera. All right.
The last slide here.
Yeah, go ahead.
Sorry, go ahead.
No, go ahead.
Well, the last slide, I think that's one you can just read. Certainly, the first thing you have to do is fix the problem. Remember, you want to be able to present a story to the government about all the things that you did that were good and beneficial after you identified the issue.
I think
then you got to figure out
critical,
who disclosed it.
Yeah, I think that's critical, and the protocols are there, and there's a variety of ways to go about it. And this talks about the 60-day known retention overpayment, otherwise it turns into FCA violation. But I really think there are some people out there who still continue to believe that, hey, or think if I change it now, I'll either fix it going forward, which doesn't work, as we just talked about, or if I change it, that's going to be evidence that I'm guilty of something. And I just think that's, frankly, a ludicrous position, because you have to stop the wrongful conduct. It shows effective compliance. It shows you're willing to do it. And you can do it in a manner like, hey, I disagree with you, government, and I don't think there's an issue here, but just to appease you and out of abundance of caution, we're going to stop coding it that way. We're going to stop doing it that way. We're going to put this type of pressure or this type of policies in place just during the pendency of this investigation, and whether you're right or wrong, but I just want to make sure that we're all on the same page, so you don't think we're continuing to do something like an ongoing fraud or something like that. I think that's critical to message as appropriate, but it also, frankly, from a practical perspective, Mike, doesn't it just stop the flow of damages too? So you're not increasing the potential loss.
Yeah, your risk for continuing with a practice to be impermissible is off the charts and grows every day. You got to stop at some point, and that's the way you do it. So you stop the action, stop the bleeding, and address next steps.
Yeah, and I think the rules of evidence address that. Like, remedial measures can't be used as evidence of impropriety. It's like the classic scenario when a car manufacturer has a problem and then they fix it, and then essentially the evidence that they fixed the problem, the engine or the seatbelt, whatever, can be used that there was a problem and they knew about it. So I think there's protections there as well. But Mike, I think we're at the end of the presentation, so I do appreciate the audience sticking with us and listening, and hope they found value here. But we're ready to answer any questions that are out there.
Hi, it's Catherine again. We did have a few questions come in, and maybe while we have the questions, can we have the slide with your contact information? Thanks. Okay, so one of the questions that we had was, what are the best practices for dealing with overpayments?
Well, I think that's something that we hit on with that last conversation. I think the key thing that we did not really, I guess, Sean, spend a lot of time on is who you disclose to, which is something that probably should be best left to outside counsel, maybe, depending on the complexity of the issue and the amount of money. There are times when the answer is write a check to the MAC. There are times when the answer is OIG.
Right. I think it depends on the nature of the violation. If it's Sterling Stark, you go to CMS. If it's a kickback or FCA, do you want to disclose it? You can try the MAC if you think there's no intentional or knowing conduct. It was simply a mistake. Knowing that, in my experience, though, Mike, that if it's a significant amount of money, the MAC or the contractor is simply going to forward it to the OIG or to the fraud contractor anyhow, the ZPIC. So, but I mean, and sometimes it's a matter of picking up the phone and calling directly the local U.S. Attorney's office and seeing if there's a way to resolve it. And I used to field those calls all the time, especially if it's simply an overpayment case. But and also there are whole presentations on the timing mechanics of how to make the appropriate disclosure, how many years you go back, how many programs. I mean, frankly, from a defense perspective, you're trying to get the most narrow possible repayment or look back period. I think the government has promulgated a draft rule. I don't know if it's final yet, Mike, but they want to look at 10 years, but I think it's 6 years. That's standard FCA kind of statute of limitations is 6 years, absent something compelling.
Right.
Okay, good. Let's see, we had another question. Do you think there's going to be any changes to Stark Law here in 2018?
Mike, what have you been hearing?
I'm biased because I want that, and maybe I want it to be true, and that's clouding my judgment. I think the time-honored argument from the provider side, the defense side, has always been, we have the anti-kickback statute, and Stark over time has become, and really has always been, but now especially, very complicated. And because of strict liability, you don't really have much to say in the way of, we didn't, this is totally unintentional. You're stuck with the result.
And I would agree. I think, with this administration, if there's ever a chance that Stark will be peeled back or modified in some capacity, or at least some regulatory relief, it's now in the next year or so. But, it's kind of become so ingrained and entrenched, how do you really effectively do that? I think maybe some additional, we'll get some notice and comments, and there may be some new exceptions that kind of, or revisions to, because most of them are straightforward, but you get very complicated when you talk about gain sharing or the definition of group practice or the revenue sharing arrangements. You're talking about structuring transactions and, how to divide up pro rata, et cetera, those revenues. I think that's really some of the more complicated stuff. And I remember when I was in AUSA, people would raise these esoteric Stark questions. I think most of those are really beyond the purview of what DOJ or even CMS is going to look into. I think they're looking at the basics. Hey, these are medical directorships or the written and lease agreements. And it really comes down to fair market value. Is it in writing? Is it commercially reasonable? And I think those are really, if it's not those, then DOJ, CMS, OIG take a look-see. But if it's some complicated transaction as to who's getting what structurally, I just don't think they have the wherewithal or the willingness to look into those.
There are enough simple ones out there to not have to delve into the potentially highly formalistic legal argument you'd have to make to prosecute it.
Absolutely, because you've got advice accounts, so you got good faith reliance, you've got, I know DOJ is really kind of coming to the jure on these so-called swapping and carve-out arrangements, but even those are very complex and are not straightforward. And I think there's enough, as you point out, low-hanging fruit out there, as we see from every national roundup, criminally, that they don't have to focus on those esoteric issues.
Good. Okay, so we had a third question, and it was, how do Medicare shared savings programs affect compliance?
Well, there's an area where, the gain sharing is maybe something that would drop out of future regulations, because I think that in order to implement these shared savings programs and some of the more innovative sort of patient care models, they're going to have to modulate the enforcement of gain sharing and some other prohibitions.
Right. I think gain sharing has been, back, now almost 18 years ago, was kind of, when it was new, it was very kind of common. And I think with the Affordable Care Act and some of these innovative models for collaboration, you see kind of resurgence, especially under ACOs. But kind of clinically integrated models and networks, I think, there's waivers for certain issues that potentially could be problematic. When we're talking about shared savings, I mean, the goal is to provide higher quality in a more clinically setted. And I have not seen any enforcement cases on shared savings stuff. I mean, unless there's like a meaningful use certification of some sort, where there's express fraud, they just didn't use it for the funds, I think the shared savings are going to be, at least for the time being, kind of off the table from an enforcement perspective. That's just my personal thoughts.
Right. I agree.
Okay, very good. Well, I really enjoyed your webinar here, and I know that our audience really enjoyed it as well. So thank you so much, both of you. And did you have any other thoughts at all, or anything? Any final parting thoughts?
No, just Catherine, thank you for inviting us to give this presentation today, and I hope the audience found it useful. And our information, Mike and I's, are there. If you have any follow-up questions, then feel free to reach out to us via email or phone, social media, et cetera, whatever. But do appreciate the opportunity to talk today. Thank you.
Right. Well,
yes. Thank you, Catherine.
Yes, thank you so much. Thank you, both of you, so much. And audience, please use the contact information on the screen for any questions. And also, if you have any other questions, feel free to send them to us, and we'll forward them on to Mike and Sean. And you can also register for any future webinars or request a demo of our compliance solution on our website, which is firsthcc.com, or call us at 888-543-4778. And thank you so much again, and thank you for joining us. Appreciate it.